Can you go in the De Jesus room, please? They're asking for help.
Yeah.
All right, let me take a quick look, real quick at the motion. Okay, so I have a first amended motion to withdraw and motion for continuance. Are we proceeding on that motion to withdraw today?
Yes, Your Honor.
Okay. Are you also seeking a continuance as you seek to exit the case as well?
Yes, just to make sure that Dr. Nouri is not
Got
prejudiced.
time.
Mhm.
And is St. Peter Medical Center, is that a corporation that's going to require an attorney, or is it some other structure?
It's LLC, and I believe it does have to be represented.
Okay, yeah, it does. All right. So let me start there, Dr. Nouri. Your attorney is asking to be let off the case for two reasons. One is his personal health, and the other is what lawyers call irreconcilable differences between himself and you, meaning that in his opinion, the two of you are no longer able to work together in your best interest, in your interest in this lawsuit. And he is asking me to let him no longer represent you, and also to give you an additional 90 days before anything happens in court. Right now, you're set for a trial on December the 4th, and then another short hearing on October the 26th. I don't know what that hearing is. So, Mr. Bowman, just to make sure I understand, you're asking for the trial setting to be reset. Is that right?
Yes, I think yes.
Okay. And the 26th, do you know what that setting is?
It's Mr. Nunes. I believe well, I'm actually not sure.
All right, Mr. Nunes, is that your setting? What is it for?
Your Honor, Margie Pabone has been handling this case for my firm. I believe it's a follow-up on a motion to compel. We've been trying to get documents for about a year. The short version is we have no objection to Mr. Bowman withdrawing. We had a hearing in January in front of Judge Iserloh, and he said, "Hey, I can't continue on. I'm sick. I need to bring someone in." She told him then, "You need to get someone." Well, we had a hearing before Judge Crump, and he says the same thing. This was about a month and a half ago, and he says the same thing. She goes, "Well, you need to get an attorney." Same thing with Judge Connor. So you're the fourth judge that they've come to saying, we want to delay this case more. And they've known since January that Mr. Bowman has a health condition, and now we don't know all the background because they go in camera on these things, but it appears that the defendants have known for 10 months that they need to get an attorney, and it just keeps getting stretched out and out. So once again, we have no objection to the withdrawal. We do object to the continuance for those reasons.
Okay. All right. So Dr. Nouri, so at this point, this is where you can tell me whether you agree or disagree, whether you want to let Mr. Bowman not be your attorney anymore, or you want me to try and make him stay on as your attorney. And you're sworn in, so you're in your office, but imagine that you're in my witness chair in my courtroom, please.
Yes, Your Honor, I do. What I want to say, I don't know what's kind of what kind of disagreement between me and Mr. Bowman. I never had disagreement with him. We always work together. This case been filed for over 2 years now. It was filed in September 2021 till November 2022, over a year and 2 months. There was no prosecution of the case. There was no progress in this case. It was silent, which is not fair for me too. I hired Mr. Bowman the first day I was served. For the whole year and 2 months, I didn't hear from him. Then once we started this case in November, another lawyer filed her appearance in this case, Mr. Baboon. Then after that couple months, when the first pleading came, Mr. Bowman told me that he is ill, and there was a miscommunication. I call him, he calls me. I cannot find him easy. For April 11, it was the day for the position that I supposed to do. I did not fail to appear in this depth. Mr. Bowman gave me the wrong date and the wrong time. When I came, said, I'm sorry, it's my mistake. I sent you the wrong date because I was confused. Then I was also penalized for this for some fees. He said, I will pay the fee. This is not the issue. Then after that, when we had the happened, I provided every single document, every single supplement requested by the lawyers for the plaintiff. I gave Mr. Bowman and I have tons of email on April 13, April 23rd, and May something. I gave him every single supplement that in my
So Dr.
position.
Nori, do you want to go and find a new lawyer?
So, Your Honor, I asked Mr. Bowman multiple times, okay, hire a co-counsel with you. He never responded to this answer. He could easy. It's not fair for me to, I'm in Detroit, Michigan. I don't know lawyers in there. I asked him to hire a co-counsel that he can help you with this case. And then, what I'm having now, I'm having a default judgment for liability, which I'm in the dark. I don't know even about this till he told me that there's some judgment. I don't know what to do, Your Honor. Shall I let him go? I know it's like marriage. If it doesn't work, it's not healthy to keep us working together. But at least it should be like his responsibility to find me a co-counsel, hire a co-counsel to I paid him already $10,000. And again, I know this is sensitive information probably to say, but I didn't get the work for this money. But that's fine too. I can, he can also find me somebody, at least work with him. He knows the case back and forth. He has it's a very simple case, Your Honor. In the depth, I presented a bunch of emails and letters, evidence from Velocity CEOs saying that we have no fund and we cannot fund Dr. Nouri and St. Peter for his account receivable. It's very clear breach of contract from their case. I know we are not litigating this case now, but just to let you know about the default that I got is clearly result of ineffective assistance of counsel.
So I think you need to get a new lawyer then. If that's what you think, I think you should get a new lawyer. So are you in agreement to allowing Mr. Bowman to withdraw from the case?
That's fine, but at least, he can, I want him to promise that he will help the new counsel with the case.
So I am going to order Mr. Bowman to prepare and deliver your entire file. Every scrap of everything he's ever gotten for you or prepared for you to you or a new counsel that you choose. And I am going to ask Mr. Nunes, I'm going to direct you to reset your hearing. I know that you've done this before, but you're going to have to do it again. And you've got to go out and get an attorney. And I'm going to give you 45 days to take care of this, Dr. Nouri.
Can I have 90 days, Your Honor?
Well, the problem is that you have a hearing set today in a couple of weeks. And I'm making Mr. Nunes wait on that. So he cannot reset it for another 45 days. The trial is set in December. I'm just going to leave that for now. I think let me look at the calendar. So that would be November 29th, which is not a good time. So yeah, why don't we go to, I'm going to say that you cannot set anything. I'm going to clear the settings and you can't set anything in this case again until December 11th. I don't know how many days that is. It's just, I'm picking December 11th. So you've got till December 11th. Mr. Nunes can set anything he wants according to the rules in this case, beginning December 11th. You have until then to get a lawyer. Mr. Bowman, you've got 2 weeks at max to give Dr. Nouri everything that's his. Everything, and it has to be in a form he can access, right? So you can't give him some kind of locked device. He needs it on paper. You got to print it out and give it to him. He needs everything he's ever given you and everything you've ever prepared. And if his new counsel wants to have a meeting, you need to give him a couple of hours for free. Okay, so
Yes,
that's
Your
the
Honor.
order. I don't have any proposed orders in this case, I don't think. You haven't given me anything, so that's a little bit frustrating as well, but if you have something, you send it to me, I'll fix it. Otherwise, I'll have to write it myself.
And Judge,
Dr. Nunes, I mean, Mr. Nunes.
well, Juris Doctor, yeah.
There you go.
There we go. We note in the motion, we don't see the mailing address, phone number, email address for the defendants. And
Oh,
so if
let's
they
get
will-
those.
Yes,
What I'm gonna put you back. I'm gonna ask you to go back in the breakout room. Dr. Nori, you need to give Mr. Nunes all your contact information. If I don't have that, I can't sign the order, and you'll be stuck in this limbo catch-22 forever until everyone pulls all their hair out. So please give him phone, email, and address. Yes, Dr. Bowman.
Yeah.
I mean, Mr. Bowman. I'm all confused.
I
now.
apologize, Judge. I did submit a proposed order for the last, but I didn't on the amended. So I have that.
Right, but
order.
I don't have, you didn't submit it to my box, so I don't
Okay.
have it.
I'll
You
just
can
fix
just
that
email
up.
it to me. Yeah,
Mhm.
that's fine. 2 weeks to give him everything. December 11th, you can go right now to court admin, Mr. Nunes, and set anything you want starting December 11th, according to the rules. Dr. Nori, you need to move fast and get an attorney. Mr.
Yeah.
Bowman, 2 hours of time for the new attorney if he asks for it, or she asks for it.
Yes, Your Honor.
I'm gonna ask you all to go back in the breakout room and exchange that contact information, and then it show up in the order. And if it's more efficient, just send my staff an email with that information, Mr. Nunes, if you're worried that I'm not gonna get it. Okay,
yes, Your Honor. Just to be clear, nothing can be set until after December 11th, but it can be set, and we'll reach out to Dr. Nori and
you can go and set something for December 11th right now. You can't have a hearing before December 11th.
I understand. Thank you.
Right. So you can pick your new trial setting, all of that. It just has to be after December 11th or December
Understood.
11th or after. Okay, so what you have to do to go to the breakout room is click on the breakout room button, or if you don't see that, 4 little boxes, click on the more button and then go into the breakout room to exchange that contact information. Can you each try to do that, please? We'll just wait for the other 2 lawyers. I see that the client is gone. I'm assuming his connection never worked out.
Yes, Your Honor. For some reason, we couldn't get the volume or speaker, whatever you want to say. We could see him,
Yeah.
but we couldn't hear him.
Let's wait for Miss Stewart. All right, so we're back on the De Jesus matter, and I'm assuming from the client's absence that we could not get his connection to work. Is that right?
That is correct, Your Honor. I apologize.
Okay, that's all right. So you're gonna reset. You can reset on Zoom if you make sure he'll be able to connect. Bring him into your office or go to him with a device, or you can reset in person. Does that sound good?
Yes, Your Honor. Or we were thinking we would do it by submission.
That's fine as well. To do a friendly suit prove up by submission, let me just tell you what gets kicked back. The numbers don't match. So one affidavit has these numbers, another affidavit has these other numbers. It's like, I'm not here to do this work for you, right? The plaintiff's attorney is getting a lot more money than their client. If it comes to my courtroom, you're going to come in for a hearing on that for a friendly settlement, right? Because the settlement shouldn't be
Mhm.
like that. No affidavit from the parent or the language we're looking for in that affidavit isn't there, right? That they've been spoken to everyone, they understand. No affidavit from the guardian ad litem, it would also be a problem. But those are really the only 2 affidavits I need, and a good explanation of the money. Because sometimes it's vague, it's just in words. The best thing is, here's the total, here's what's going here, here's this bill, this leaves the client with this, the attorney's taking this, the fees are this, the guardian ad litem is being paid by the defendant this much. It's all clear, it all matches, then I sign them, no problem.
Okay.
Okay, yeah, so that's fine. Submission is fine. I don't know which court you're in, but I think we all handle them approximately in the same way.
Sounds good.
Thank
All
you.
right, sorry for the technical troubles. You're all excused. Have a great day.
Thank you.
Oh,
Weekend.
I forgot you guys were in the breakout room. I'm so sorry. Had you had time to exchange information? That was 100% my fault. You're on mute, Mr. Nunes. Sorry, everybody. I'm on to my last hearing, and what I do with the last hearing is I close all the breakout rooms, but I forgot I had sent you guys back. I apologize.
Your
Your
Honor,
Honor, but we just want to go ahead, Mr. Bowman.
No, go
I
ahead.
just want to verify to confirm how many days I have or till when I have to find new lawyer.
You are going to have a hearing on December the 11th. That's my expectation.
So I have till December
Yes.
11th to
Well,
find a lawyer.
I would do it sooner than that, but yes.
Thank you.
Okay. Anything else? Did you exchange your personal information?
Yes, we did.
Okay, and
Yeah.
someone is going to email that to my office, so I know it gets in the order.
Mr. Bowman said he was going to put it in the order. He has drafted a previous order. It just needs to be modified for this amended motion, and he's agreed that he'll put that information in the order.
All right, send it to me in Word, Mr. Bowman, okay?
Yes, Your Honor.
All right, Dr. Nouri, Mr. Nunes, Mr. Bowman, your hearing is over. You're excused. Thank you very much. You may all
Thank you.
go. Vlai versus Harvey Davis Garrett, Mr. Knickerbocker here for Ms. Vlai. And I'm sorry you've had to wait so long, especially because I think you might have a notice problem on your hearing. So let me pull that up and see.
Alrighty.
You're here on a motion to enter, is that right?
It's a motion to enter, Your Honor, yes.
Okay, but this is weird because all I have is a notice of final hearing for today.
Which is what the, I think it was the administrator said that we were requested to do a final, but it's an agreed order. So we're not sure why it was requested.
Did you
to be
send it
final.
into submission and it got rejected? Oh, by me, it looks like.
Yeah. So,
Oh, okay, so I set this case, okay.
Yep.
Oh, I kind of remember this, yeah.
it's a New
So-
York order and
Yeah, so here's the problem. The notice, your notice of final hearing is not proper notice at all. It doesn't tell anyone what to do or where to go or how to be here in any way, shape, or form. And we have a sample language on the website to tell you exactly how to notice a Zoom hearing or an in-person hearing. So, but while we're here, I want to take a quick look at my notes so I can tell you why I had a problem with it. Yeah, but I'm not going to be able to sign it today. I don't even have evidence in the file that he was served with your original petition. The only thing in the file is the petition, a vacation letter, and the notice of this hearing today, which, as I've described, is not, it's not proper to protect due process, so I can't rely on it. So it looks like your proposed order is missing the required information about the parents under Texas Family Code 105.006. And the changes are pretty dramatic. So you were in New York, I think, joint managing conservators, and the switch is to sole managing with no geographic restriction for Ms. Lai, and Mr. Garrett reduced to a possessory conservator that does not even receive written notice if Ms. Lai intends to travel outside the country with the child. The standard possession order, even though they live more than 100 miles apart, the order is required to have the language for both when parents live within 100 miles and outside of 100 miles. So I need that in the order. There's a teenager provision, which is okay, because it's requesting additional possession, but typically do like some evidence somewhere as to why we need to do that. And then it looks like there's no child support ordered,
Correct, Your Honor.
even though the income is in the New York order, the justification, and I don't know what the law in New York is on child support, but in Texas, you have to have it unless you convince me with evidence that it's in the best interest not to. And the recitation in the New York order is that the parties agree to opt out because they're sharing equally the role of residential parent, and that's no longer true based on the information you're giving me. And so I would need some other evidence to justify an award of no child support. Otherwise, I think the law requires me to order child support. And then we do accept on occasion signatures that are not really signatures, just typed out names, but not when there are also so many other issues and questions, right? So like if I had a waiver of service and an answer, or he was in Travis County also, or do you see what I'm saying? Or you weren't changing any orders from New York, it was just exactly the same, but in Texas, then I would be like, okay, that's fine. But because we're changing so many things and all I have is an email address and a typed out name, I don't have any of that assurance that he's really in agreement with this. He may very well be. I am not saying you're trying to trick the court. I'm just saying I'm required to have some more evidence about that kind of thing. So as an example, justification for no child support in a case like this could be that he's paying all the travel expenses for his visitation, something like that, right? Or his financial situation has changed, or yours has changed, and now you make twice as much money as he does. I don't know. My point is not that you can't get what you want, it's that you have to tell me why. So, let's see if there's anything else in here to try to remember. Yeah. I also don't know, I couldn't, like, because the parental information's not in the decree, I don't even know if the father knows where his child is living. That's how we guarantee that each parent knows the address of their child. Maybe you have a reason for that, but again, I don't have that information. So just in terms of a submission, I have to talk to get more information. Oh, also, I'm trying to remember if health insurance was included in the decree. I didn't print out the whole decree. I'm sorry. Oh, yes, I did. I lied. It's all right here. So I can look through it, but maybe you know off the top of your head whether there's a provision for health insurance, because that is required under Texas law as well. So now that you've heard all that and you know I'm not signing anything today, do you have any questions, or do you just want to go and fix everything up and resubmit it when you've got it all, or set it for a hearing if you can't get it all together?
Right. Well, that gives us excellent guidance to be able to go in and change it. It is odd transitioning from a New York to a
It
Texas
is.
and trying to track that, especially when we now have Texas and Georgia and agreements to have it one way. So, but completely understand. I know child support has been a back and forth question. Hearing it directly from Your Honor definitely helps us have guidance to be able to talk about why we need to address that a little deeper. I'm not sure why the waiver of service isn't on file. We do have one signed. I'm not sure.
Oh, good.
The e-filing, but yeah, we do have one.
Okay. Yeah, that would help too.
Okay, well, we'll find out why that got kicked out or what happened
Yeah,
there.
just refile it. If you filed it as an attachment to your petition, that's probably not best practice. File it separately.
Okay.
I don't know that you did. I'm just saying if that's the reason, because I'll never see it.
Yeah, I think it was separate. So
yeah. So yeah, it didn't make it through for whatever reason. It could be the clerk's fault. I have no idea, but that waiver will be very helpful. Ms.
Okay.
Bly, do you have any questions? Mr. Knickerbocker can explain everything I said that you didn't understand, but since you're here, I thought I'd offer.
Thank you, but no, I don't have any questions.
Okay. All right. So if you do decide to try again via submission, that's perfectly okay. Just make sure you address all those things in your statement of evidence. Put the things I need in the order, but also you can set it for another hearing like this on the central family docket. That's fine too. You don't have to come back to me. If you come back on submission, it'll be to me because I'm the court that this case is filed in. Okay.
Okay.
Got it.
All right. Any other questions from you, Mr. Knickerbocker?
No, I believe that covered everything. Thank you, Your Honor.
All right. Thank you. You guys have a wonderful day. You're free to go. Thank you so much.
Thanks, Judge. Bye.
Bye.